News.
Okay. Good evening to you all. I see that you are already 142 connected, so I think we can kick off our evening. My name is Rebecca Mignot-Madavi, and I'm researcher in the Human Dignity and Human Security strand at the Asser Institute. So welcome to the Asser Institute virtually and to our event. Tonight's webinar is organized in the context of HILAC, which stands for the Hague Initiative for Law and Armed Conflict. The HILAC lecture series has been organized since 2005 by the Asser Institute in cooperation with the Amsterdam Center for International Law and the Netherlands Red Cross. Tonight's webinar is co-organized by the International Humanitarian and Criminal Law Platform, which is an inter-faculty research platform on international humanitarian and criminal law in which various Dutch and Belgian organizations and universities participate. Tonight's discussion will be on how the Syria conflict has changed international law. And we are absolutely delighted to have with us three fantastic speakers who I will now introduce to you. And I should stress, of course, in advance that what follows is just a very brief selection of the speakers' very impressive backgrounds. So my apologies in advance for being selective. Michael Scharf is the Dean of Case Western Reserve University Law School and the Joseph Baker Hostetler Professor of Law. He began his career as attorney advisor for UN Affairs at the US Department of State and has authored over 100 articles and 20 books for which he won several awards. He is also the host of the very engaging NPR's Talking Foreign Policy radio program broadcasts. And in addition, Michael serves as managing director of the Public International Law and Policy Group, a Nobel Peace Prize nominated NGO. Scharf has led USAID-funded transitional justice missions to the Ivory Coast, Libya, and Uganda, and very interestingly for our conversation tonight, headed the Blue Ribbon Committee that drafted a statute for a war crimes tribunal for Syrian atrocities. Milena Sterio is the Charles Emmerich Jr. Coffey-Halter Griswold Professor of Law at Cleveland Marshall College of Law. She began her career as attorney at the New York City firm of Cleary, Gottlieb, Steen, Hamilton. She has published very influential papers in top journals in the field of international law, international criminal law, international human rights law, law of the seas, and in particular, and maritime piracy, as well as private international law. And she has published 5 books, including one that recently won a National Book of the Year award on the legacy of ad hoc tribunals in international criminal law. Dr. Paul Williams holds the Rebecca Grazier Professorship in Law in International Relations at American University, where he teaches in the School of International Service and at the Washington College of Law. He's also the co-founder and president of the Public International Law and Policy Group that I mentioned before, and maybe I can tell you a few words about it. It's a pro bono law firm providing legal assistance to states and governments involved in peace negotiations, post-conflict constitution drafting, and the prosecution of war criminals. So as a world-renowned peace negotiation lawyer, Dr. Williams has assisted over 24 parties in major international peace negotiations and has advised numerous parties on among other things, the drafting and implementation of post-conflict constitutions. For the past 7 years, also interesting for our discussion, Dr. Williams has been advising the Syrian opposition in the Syrian peace negotiations, also referred to as the Geneva and Astana peace negotiations. Dean Scharf and Professors Sterio and Williams have recently, this year in March, I believe, co-authored a fascinating book, The Syria Conflict's Impact on International Law, which was published by Cambridge University Press, and hence the topic of this discussion. So what I suggest is that we start with a roundtable for about 45 minutes, after which we will open the floor to a Q&A session of about 30 minutes. So you can already start sending your questions on the chat. Just make sure to send them to all panelists. So welcome to you three. Maybe we can start by a little bit of context. So Paul, maybe I would like to ask you if you could give us a quick summary of the Syrian conflict. Tell us a little bit about who are the players, what are they fighting for?
Yeah. Thanks, Rebecca. Thank you for those introductions as well, and thank you to the audience for taking time in your evening or your afternoon to spend with us discussing the Syrian conflict in international humanitarian law. In order to get your head around the Syrian conflict, there's three important things. The first is that this conflict is nearly a decade old. It started in 2011 as part of the Arab Spring transitions in the region. And there was a lot of hope and optimism that this would be a political movement which would generate some democratic reform in Syria. It didn't turn out that way. The protesters were met with overwhelming force. And today we have a conflict which has generated 12 million. Half the population of Syria is displaced. 6 million are internally displaced and 6 million are refugees. It's also been met with dramatic atrocities. Over 500,000 individuals have been killed through chemical weapons attacks, barrel bombs. It's a brutal and a vicious war. And then the third aspect is oftentimes folks will consider or be worried about a spillover conflict, that a conflict will affect the neighbors. In Syria, you have a spill-in conflict. So you have the Iranians with their Hezbollah allies and with Russia, who've spilled in to support the government. You have Turkey, the United States, the French, the British, Qatar, Saudi Arabia, who've all spilled in as well, to some degree to ally themselves with the Free Syrian Army, but mostly to protect their own interests. And you have conflicts within conflicts. You have the conflict between the government and the Free Syrian Army. You have Al-Qaeda and ISIS, who joined in both the government and the Free Syrian Army, and the Syrian Democratic Forces, which are Kurdish Arab forces, are fighting Al-Qaeda and ISIS. And then you have Turkey engaged in a military conflict with the Kurdish forces that the Americans are supporting. So basically it's brutal, it's long, and everyone has sort of joined into a number of powerful interests have joined into the conflict in order to protect or promote their interests. And we're a long way from the democratic transformation that the protesters set out to accomplish in 2011.
So if we now look a little bit about at how the conflict affected other parts of the world, now that we have a good sharp picture of the conflict, why do you think that other countries, including in Europe, for example, but also elsewhere in the world, should care about the Syrian conflict? And maybe Milena, if you could address this question.
Sure. So as Paul already mentioned, the conflict has already lasted for almost an entire decade and has been one of the worst humanitarian crises in our history, and certainly in our recent history. The conflict has not only destabilized the region, the Middle East, but it has also somewhat destabilized the rest of the world. And one notable effect of the conflict has been a very large migration of Syrian migrants and refugees to Europe and to some other parts of the world, particularly towards Europe. The very large influx of Syrian migrants and refugees has certainly put a lot of strain on some of the European countries that have received those migrants and refugees, has caused significant debate among the public and policymakers in those countries about the best immigration and sort of migrant welcoming policies, has been a contributing factor perhaps to Brexit in the UK, and has definitely caused changes in the international arena. One other notable thing that I would mention in this area of migration is that in 2016, United Nations member states got together and began negotiating a global compact on refugees and a global compact on migrants to develop best practices in terms of allocating responsibilities among host countries for taking care of migrants and refugees. So we have seen lots of changes, if you will, not just in the Middle East, but throughout the rest of the world.
Mm. So now that we have a good picture of the macro, I would be interested to delve a bit into a story that, so I already mentioned your book, the Syria conflict's impact on international law. So the book begins, Michael, with a prologue about the time you and Paul were tear gassed in Istanbul. And I would be interested, and I'm sure the audience as well, if you could tell us a bit about the relevance of that story to the Syrian conflict.
And, you know, Paul and I, and Milena as well, as part of our work, have often been sent into post-conflict situations that are still unstable. We were in Libya, Cote d'Ivoire. Paul spent time in Yemen. But who knew when on June 10th, 2013, Paul and I were at an outdoor cafe sitting at a Starbucks in the nice, beautiful city of Istanbul, that we would soon be subject to tear gassing, rubber bullets, water cannon shots, and running with a crowd for our lives. But that's in fact what happened that day. And the particular element that began that was that Erdogan was talking about transforming the Taksim Square, which was a traditional place of protest and relaxation, into more of a shopping center. And at the same time, he also said that he was going to put curfews and bar students from getting alcohol after 10 o'clock. I mean, this really got the students up in arms. So they started to protest in Taksim Square. Paul and I were in Istanbul to meet with Syrian judges and prosecutors and defense counsel to create the possible regional or internationalized tribunal that would prosecute Assad and the other leaders who had been using chemical weapons and barrel bombs and committing other atrocities. And so we were going to meet with them the next day, and we were just planning out what we were going to do. Well, the riot police attacked the students. The students ran from Taksim Square to where we were. We were suddenly surrounded by noisemakers and students with Ataturk flags and everything you can imagine. It for a minute or two, it was exciting. And then once the tear gas fell and the water cannon started to shoot, it was a stampede. And, you know, they talk about the flight or fight phenomenon. We weren't fighting. We were running as fast as we can. And I'm sure Paul felt the same way. We just didn't want to be stampeded and trampled. We were able to get away and get back to the hotel. And the next morning, we talked to the Syrian judges and prosecutors and defense counsel. We said, were you there when this happened in front of our hotel? And they said, oh yeah, we were there. And we said, did you run? And they said, not away. We ran toward the police. We picked up tear gas canisters and threw it back at them. We grabbed Ataturk flags and were waving them. We're like, oh my gosh, weren't you nervous? Weren't you worried? And they said something that we put in the prologue of our book. They said, listen, we're at our home in Syria. We are being attacked by chemical weapons, Scud missiles, barrel bombs, every atrocity you can imagine. Compared to that, this was just child's play. This was democracy. This was fun. And they were really courageous. And so we dedicated our book to them. Some of them aren't alive now. You know, some of them have paid the ultimate price. Some of them have become refugees like Milena was describing. And some are still in Syria fighting for democracy and justice.
So can you tell us a little bit more about the Syrian War Crimes Tribunal and maybe the status of the draft statute?
Yeah.
Tribunal.
So what's really interesting about the statute, and we decided to put it as an appendix of our book because it's really a great teaching tool, is that we decided not to be arrogant. We weren't going to just say, this is the best statute for you. What we did is we looked at every statute that had been adopted for, like the Iraqi High Tribunal, the Cambodia Tribunal, the Special Court for Sierra Leone, the Lebanon Tribunal, all these different kinds of models. And we told them what the options were and what the pros and cons of each option was, and also how they had been interpreted. And so the tribunal is really just a series of options for them to pick and choose from in a very informed way. And we've heard from law professors that they actually use this statute as a teaching tool to teach international criminal law. Now, what's going to happen in terms of Syria using it? At the time we were there in 2013, there was a lot of optimism that the Assad regime was going to fall, and everything has changed since then. You know, it seems like for the most part, Assad is just cleaning up. We're seeing the end game of the revolution, and it does not look like in the short term there's going to be trials for the Assad regime. But one thing that Paul and Milena and I always say, international justice is patient and persistent. And people like al-Bashir from the Sudan, you know, for a while he was just flouting the International Criminal Court's arrest warrant for genocide. But now he's fallen from power, and his own people are planning on sending him to The Hague. Ultimately, something like that could happen to Assad and the others responsible. And this statute will be around for that day.
Another very interesting part of your work concerns the idea of Grocer moment, the concept of Grocer moment. And maybe this question goes more to Milena now. So you, as well as other scholars, have written about this concept of Grocer moment. Maybe you could tell us a little bit about this concept and its importance for international law before we attach it to the Syrian conflict.
Sure. So the idea of a Grocer moment, obviously it's a reference to Hugo Grotius, the very famous, world famous Dutch scholar and really forefather of international law. A Grocer moment is the following idea. Normally, when we think of customary law evolves over decades, if not centuries, through persistent, continuous state practice. So it takes a lot of time. A Grocer moment is a moment of accelerated formation of customary norms as a response to some cataclysmic or catastrophic world event. So you can think of Nuremberg, you can think of 9/11 in the more recent history, and then perhaps we can talk about Syria today. But we're talking about these cataclysmic events on the world scene, which cause international norms to form in a more accelerated manner to basically respond to these cataclysmic events. And so the book that you mentioned, which was just published a few months ago, talks about Syria as a potential Grocer moment, and whether Syria, which is obviously this catastrophic event or series of events, has caused the formation of new customary norms in an accelerated way.
Yeah, I can't wait to delve into this issue a little bit more. Maybe Paul and Michael, if you want to add something about this conceptual framework first.
Go ahead, Paul.
I would just add that we're now seeing situations like Syria where you have a compressed time frame because so much happened. So it's if you're one of the victims of the conflict, a decade is an exceedingly long period of time. But if you're approaching it from the perspective of customary international law, there have been dozens of Security Council resolutions. There's been rapid initiatives relating to the hybrid tribunal, universal jurisdiction, the independent impartial mechanism. Things happen much more rapidly now in this modern generation, but I think push or accelerate the development of international law, customary international law in a Grocer moment. It doesn't happen everywhere all the time, but I think when there's intense focus on a particular conflict or a particular situation, you have that crucible that can give birth to new laws and norms.
Yeah, I would add, normally scholars and practitioners of international law believe that customary international law crystallizes slowly. The word crystallizes, that sounds like something that takes millennia, let alone decades or centuries. And most people would not expect customary international law to be able to form very quickly. But over the years, there have been situations, and I think there are some commonalities that explain it. Usually it's like something that's a transformative moment in history. World War II and Nuremberg was transformative. And I think you can argue that Syria is such a long conflict. It involves so many characters that it has become transformative. The second thing is you don't have the Security Council able to create law through Chapter 7, in this case because Russia has been using the veto. So you're not getting law being created by the UN mechanisms. And the third thing is there is no treaty mechanism that is able to keep up with the pace of change. And so what we're seeing in a lot of different areas involving this conflict is new law that is being crystallized and the world sort of embracing it. And there's got to be some term for it. Some people call them international constitutional moments, but we're not really talking about a constitution. We're talking about customary international law. So the three of us, along with other scholars, like to refer to these as Grocer moments.
So Michael, maybe now we can get to the big question, and I'm tempted to ask you if you believe that then the Syria conflict constitutes a Grocer moment, and if so, I would invite you to also maybe compare it to other Grocer moments, such as the Nuremberg trial after the World War II, or other Grocer moments.
All right, so Nuremberg's a good one to use. Before Nuremberg, before World War II was over, there wasn't really a concept of international criminal law or human rights law. What a country did to its own citizens was its own business. There had never been an effective international prosecution. Nuremberg is a one-year trial. It involves 4 great powers and 17 other countries that were just sort of bystanders that acceded to the Nuremberg Charter. And at the end of the year, the UN General Assembly endorses the principles from Nuremberg. And those principles lay the cornerstone for international criminal law, things that continue to this day to be binding customary international law. Who would have thought that a one-year trial could have changed so much? And that's a good example of what we're seeing in the Syria situation. So let me give you the example. There are things in Syria like, can a country attack terrorists in another country when the other country's government is not responsible for the terrorists? And in the case of Syria, it's ISIS. ISIS is hanging out in Syria, but it's terrorizing the world. The United States came up with this theory and said, well, the United States can attack them because Syria is unable and unwilling to prevent them from being a threat. And at first, the rest of the world, they weren't buying into this. But then one night, the ISIS terrorists had a series of attacks in Paris. We all know about this in 2014. It was horrible. They attacked the discotheques and the sports stadiums, and hundreds of people from many different countries were killed. And the Security Council woke up, literally woke up and said, ISIS is not just a threat to the region. It is a threat to the world. And we need to do something about it. And the US has been making this argument. And guess what? We're going to endorse it. And so the Security Council did not, contrary to what some people have argued or said, they did not authorize the use of force against ISIS. There was no Chapter 7 authorization. What the Security Council said was that countries who are being attacked by ISIS have a right of self-defense. And what that meant was what the United States had been unsuccessfully arguing had now become a generally blessed concept. And it wasn't just the Security Council. Suddenly, all the countries in the world that weighed in on this said, yes, that's of course the truth. Any country can attack ISIS. Now, that precedent is really interesting. Is it confined to Syria? Is it confined to ISIS? Does it require a Security Council blessing in some confirmation of self-defense? Of course, you note that, or you might have noticed that Turkey has tried to use the same argument for attacking the Kurds in Syria. And that raises the question of, well, is this new concept being abused? Is it too broad? Is it too dangerous? Does it need to be bottled up again? And that's the thing about Grocer moments. That's why they're a little scary, because they happen quickly and they can sometimes let the genie out of the bottle, so to speak.
So that's very interesting. Now we are getting into the details of how norms evolved at the contact of or in the context of the Syrian conflict. So saying a bit more about on the law, on the use of force and the right of self-defense. Indeed, we have seen an evolution of the traditional and international law interpretation of what, in what conditions the use of force is allowed against non-state actors. So moving from the idea that the territorial state has to be in effective control of the non-state actors, to a looser interpretation of the right of self-defense. Maybe I would be interested in also hearing Paul and Milena on this October situation with Turkey invading Syria and establishing a buffer zone to protect itself from its from what it characterized as Kurdish terrorists. So was this use of force, according to you, permitted under the right of self-defense, under the traditional interpretation, and then as newly interpreted?
Milena, do you want to go ahead and take a first whack at that, and then I'll follow up?
Perfect. As Michael mentioned, there has been this evolving concept of the law of self-defense, because the traditional law of self-defense allows a state to respond if it has been a subject of an armed attack. And then perhaps we can add to that the idea of anticipatory self-defense. But the traditional law of self-defense really contemplates a situation where state A is defending against state B, or state B is defending against state C, but it doesn't really talk about non-state actors. And so this evolving concept of the law of self-defense says that basically if they're as Michael already explained very well, if they're non-state actors such as ISIS acting out of Syria, but the Syrian government isn't doing anything about it, then other states can go ahead and act against ISIS if they're being attacked by ISIS. So what Turkey did, though, in order to if one accepts this new evolving form of self-defense against non-state actors, you would have to say that basically Turkey was somehow the subject of attacks by the Kurds, right? And the Kurds, the Syrian government wasn't doing anything to stop the Kurds. And so then Turkey was allowed to respond against the Kurds. That's a difficult argument to justify, because it really doesn't appear that the Kurds were attacking Turkey in any shape or form. If anything, you might say the Kurds are fighting to have their own independence, but for the most part, they're doing so from within Syria. So I'll stop there and I'll let Paul continue.
Yeah, no, I would just add, picking up on Milena's train of thought, is that one of the challenges, or one of the risks with Grocer moments and customary international law crystallizing fairly rapidly, is that it can be abused. And so just as much energy that's being put into identifying this crystallization of new law, that energy has to be matched with an effort to articulate a very clear framework. We saw this with the responsibility to protect, the Kosovo intervention, Libya intervention, but you've seen it abused in Crimea, Abkhazia, South Ossetia, and other places. And I think that's what you've seen here in Syria. You've had a legitimate evolution, rapid evolution of the definition of self-defense and what states can do in order to defend themselves against ISIS and Al-Qaeda, global terror organizations. And Turkey has reached out and grabbed that rationalization and applied it to its own strategic interests. And they've conflated their conflict with the Kurdish PKK in Turkey with the conflict with the Syrian PDK, which is focused essentially exclusively within Syria. And they've used that as a rationale for a buffer zone. Interestingly, this buffer zone has two elements of self-defense. One is vis-a-vis the PDK Kurdish population, but the other is by pushing in this 20 kilometers, 12 miles, it's also a buffer zone vis-a-vis Syria. So it's the state-to-state self-defense as well as the state to non-state actor. But because I think the government is rapidly articulating the limits of this new doctrine of self-defense, it may be subject to abuse.
Yeah, and so let me add, as the doctrine was being formed, it actually was articulated first, most fully, by the legal advisor of the State Department during the Obama administration, Harold Koh. And he made it clear that there had to be the traditional elements of necessity and proportionality. And so I think Milena was talking about necessity. Yes, Turkey has been attacked by Kurdish terrorists. Are they the same people that are Kurds that are fighting for independence in Syria? probably a pretty long, it's hard to make that linkage so explicitly. So necessity is a difficulty. But in this case, proportionality is the real problem. What is Turkey really trying to do? They're creating this buffer zone. They're actually taking some of the millions of refugees that have poured from Syria into Turkey, and they're placing them back across the border in Syria in this buffer zone area to get rid of them. Now, that cannot possibly be related to self-defense. And I think that that's where the house of cards for the traditional elements of necessity and proportionality fall.
Very interesting. So going back maybe to something you mentioned, Paul, and the idea of states exploiting legal uncertainties, but also more generally the institutions of the international legal order. One of the unique aspects of the Syrian conflict has been Russia's persistent use of the veto in the Security Council. So I would be interested in hearing your thoughts on whether and how this has led to changes in international law.
I think the Russians have been very dynamic in their use of both the veto and then also sponsoring and voting for resolutions. Early on, the Russians were very opposed to the imposition of sanctions. They vetoed that. They vetoed a 2012 resolution condemning the atrocities being committed by the Syrian regime. And then most recently, they vetoed a French effort, which ironically enough, the Americans voted in favor of, to refer the Syria situation to the International Criminal Court. But in the middle, the Russians were very active in utilizing the Security Council to authorize the ceasefire negotiations that took place in Astana, which was Turkey, Iranians, and the Russians, oddly enough, that came together for that. So they have been active in using it in order to further their agenda, and they put forward a number of draft proposals which have been vetoed. But I think what we're left with is a freezing of the ability of the Security Council to operate in the Syria context, given the most recent multiple and quite frankly aggressive vetoes on things that would seem commonsensical. And so the international community, it has momentum. It won't just stop and not do anything on the Syrian crisis. It has taken action in its own hands, so to speak. The Americans, the French, the British engaged in humanitarian intervention in response to chemical weapons. The General Assembly created the independent, impartial investigatory mechanism for Syria. You had a number of countries engage in universal jurisdiction. And so, as Michael has pointed out, the norm of justice is persistent and patient, but it's also very, very aggressive. And so you've seen these developments in international law. You've seen tremendous presence of accountability in the peace process, at least by one of the parties, the Syrian, the High Negotiating Commission for Syria. And it can't just be stopped. This momentum for justice, accountability, truth, and the legal principles which underlie justice and truth haven't really been effectively derailed by the Russian veto. All we've really derailed is a shift of power, a power shift essentially from the Security Council to other actors, some multilateral and some institutional.
Thank you.
Rebecca, if I might just jump in on one quick point on that. So Paul, you were asking about the Security Council. One of the things that I wanted to mention, one possible development sparked by the Syrian crisis might be a conversation about the legal limits of the use of the veto power when atrocity crimes are being committed. And one of our colleagues, Professor Jennifer Trahan from NYU, actually has a book coming out on this from Cambridge University Press on the limits, on the legal limits on the use of the veto power in the wake of atrocity crimes. And I know that there was just an event last week, I believe, out of Cambridge that on the same topic. So not to say that the permanent members of the Security Council are thrilled about this idea, but to argue it, but to argue that at the very least there's a conversation being had about the limitations of the Security Council and the fact that when there are atrocity crimes taking place, perhaps something ought to be done to essentially at least, stifle or limit the veto power by the permanent members.
Can I take up another one of the threads that Paul mentioned, and that is the IIIM, the investigative mechanism that the General Assembly created, because it's a really good example of what we're talking about here. And I want to dive into it in a little bit more detail. So what happened is the Security Council wanted to investigate the chemical weapons use and the atrocities in Syria. And all the countries were willing to have an investigation be created and have a commission like had investigated the Rwanda atrocities, the Yugoslavia atrocities, and so many others. And Russia, which has historically protected Syria, and in part because it has its major warm water port in Tartus, Syria, and it'll do anything to keep the Assad regime in power and not to weaken it, it vetoed that. And it vetoed a series of resolutions that would do nothing but hold people accountable and investigate the atrocities that were going on there. So one of our friends who should be well known to the community in The Hague, Christian Banaveser, and the reason I say well known to your community is because not only is he the ambassador of Liechtenstein, but he served for a number of years as the president of the Assembly of State Parties of the International Criminal Court. Well, he is Liechtenstein's permanent representative to the UN. And when this happened, he went to the General Assembly states parties. And he said, listen, if the Security Council is paralyzed, why don't we do it? Why don't we create a criminal investigative body to manufacture cases that will one day be turned over to an international tribunal? And of course, Russia said, well, you can't do it. You're the General Assembly. You don't have the power to do it. The Security Council has the power, but even that was, questionable until the Yugoslavia Tribunal in its first appeals chamber decision said that the council had the power to create a tribunal and to create investigative mechanisms. The General Assembly, it doesn't have that power, said Russia. But the General Assembly countries, in the way that Milena was describing, and Paul, there was a power shift. They were tired of the paralysis. They weren't going to stand by and allow these atrocities to occur and nothing to happen. So they voted in favor of this investigative commission. And it's a major change in politics and law at the United Nations. I would say it is as big a deal as the Uniting for Peace resolution that was passed in 1950. And scholars of the UN will remember that that was a period of time when Russia was, then the Soviet Union, using its veto to keep UN peacekeeping troops from being sent to conflict situations where they were really needed. And the General Assembly basically did the same thing. They said, we need to do something. They passed an extraordinary resolution and they claimed this authority that nobody thought they had. And now it's been 70 years, but it's happened again. And it's happened because of the dynamics of the Syria situation.
So moving to another legal framework, and maybe this question goes to you, Milena. So the Syria conflict has created the largest refugee crisis since the Second World War. Some have suggested that the presence of Syrian refugees in many European countries has sparked novel use of the concept of universal jurisdiction when it comes to prosecuting potential Syrian perpetrators of atrocities in national courts of these European countries. So could you tell us a little bit about it?
Sure. So as most of our audience probably knows, universal jurisdiction is a fairly controversial basis of jurisdiction and not a favored one, because a true universal jurisdiction prosecution involves a country using its courts and prosecutors as essentially, taxpayers' money and resources to prosecute a potential criminal and crime that has no nexus to the prosecuting country. In the wake of the Syrian crisis, however, we have seen a renewed use of universal jurisdiction to prosecute Syrian perpetrators or accused perpetrators of crimes, because in the absence of Security Council action, in the absence of other accountability mechanisms, Syrian perpetrators might never face justice. Right? We all know that the International Criminal Court has limited jurisdiction, can only prosecute if the crime is committed on the territory of a member state, or if the accused is a national of the member state. That basically creates a vacuum. It excludes Syrians from prosecution by the ICC. And as of now, we don't really have another ad hoc or hybrid mechanism created. And so because of that, and also because of the presence of Syrian migrants in some European countries, we have seen national investigative and prosecutorial authorities express an interest in prosecuting those Syrian suspects in their own domestic courts. And so the most notable case that I would mention is the ongoing prosecution in Koblenz, Germany, of 2 Syrian individuals who are accused of having committed horrible atrocities or having ordered atrocities to be committed in Syria. And what's interesting is that these individuals were actually already located in Germany. They had actually come as migrants, if you will, to Germany. So when this investigation began, when they were arrested, they were already in Germany. And the presence of other Syrian migrants in Germany has facilitated the prosecution, because the German prosecutors were able to reach those potential witnesses and victims much more easily, because they themselves were also in Germany. And so we're seeing the unfolding of national prosecutions in Germany and perhaps in some other European countries on the basis of your universal jurisdiction of these Syrian perpetrators of atrocities, who otherwise would have very little connection to those, or no connection whatsoever to the prosecuting countries.
Thank you very much. Paul, Michael, do you want to add?
The Security Council. So in a sense, the Security Council saw that there was this evolution of international law outside of its orbit, and then it brought that back in. It did act with a humanitarian intervention in the case of Libya, authorizing the use of force there. But then in the case of Syria, and Mike can probably go into greater detail on this, they reverted back to the Kosovo precedent, where the Americans, the British, and the French, first the Americans unilaterally, and then the British and the French undertook action in response to the use of chemical weapons without authorization. You had the seeds of this in the Obama administration, which said the use of chemical weapons would be a red line. If it was crossed, America would respond with use of force. The Security Council wasn't in the Obama administration's conversation. This was a unilateral statement by the US government. It wasn't acted upon by the Obama administration. It was only acted upon a number of years later and after a number of additional chemical weapons attacks. But I think you've actually seen it come full circle back to the Kosovo precedent. And now we all have to decide, is it really illegal but legitimate, or was that just papering over with words? And in fact, we now have a new legal doctrine.
So here's what
I might have some more on that.
Yeah, here's what's different between the Kosovo situation and Syria. In Kosovo, the major powers were afraid of setting a new precedent that, as Paul was suggesting before, could be taken out of context, could be subject to abuse. They were very afraid of the slippery slope of humanitarian intervention. And they had good right to be. I mean, Russia has used the R2P doctrine to justify things like the attacks on South Ossetia and on the Crimea, which is not at all what the rest of the world felt were legitimate uses of humanitarian intervention. But here's the difference. After in Kosovo saying that it's all sui generis, it's not a precedent, we want to keep it bottled up, it's only because these 15 different factors apply. The United Kingdom in Syria articulated a very detailed explanation of why attacking the Syria chemical weapons facilities in April of 2018 was justified as humanitarian intervention. And they mapped out 3 different criterias, and they explained why the facts met each one. Now, if just the United Kingdom had done that, that would have been just the UK. The extraordinary thing is that Nikki Haley, who was the US ambassador to the UN, got up at the Security Council and she said, we are in full agreement with the United Kingdom and in lockstep. And France said similar things, not quite as explicit. And the thing about a Grocer moment is it takes state practice it is accelerated, but it takes a really clear statement of opinio juris, and that's the statement of law that the United Kingdom made and that the US endorsed. Now, there have been people who look at Nikki Haley's statement and are trying to backpedal. They say, oh, Nikki Haley, anybody who knew her knew that she kind of was a rogue operator. She didn't follow guidance from the State Department. But that's irrelevant in international law. If your spokesperson at the Security Council articulates law, that binds your country. And the second thing they've tried to do is say, oh, well, maybe what Nikki Haley was saying is the US was in full agreement and in lockstep with the targets that were selected. But that's not at all the way the statement is worded or sounded. And so to the rest of the world, this is a big deal because some of the major powers have now articulated very clearly that which was not articulated back in Kosovo. And that has pushed this law forward in a way that it wasn't able to be pushed back in 1999.
And actually, Rebecca, just to add on that point, Michael mentioned Nikki Haley. Nikki Haley, some had suggested perhaps she was confused. Nikki Haley famously said, oh no, I don't get confused. So, she herself refuted this notion that she somehow didn't mean to say what she had said. And as Paul and Michael both already stated, the biggest difference between Kosovo and 2018, the airstrikes against the Assad regime in Syria, were the legal rationale expressed by the countries striking in Syria in 2018, basically saying it's humanitarian intervention, it's legal under these circumstances, and the rationale offered at the time of the 1999 airstrikes on the territory of the former Yugoslavia, where the intervening nations claimed that this was legitimate, that they had the moral authority to act, that perhaps this was an emerging norm of international law, but there's a really stark difference between the two, although the actions are really the same, right? But it's really the opinio juris part, that the legal rationale offered that differs from 1999 to 2018.
Well, in some ways the actions are a little different. And this is interesting because we keep talking about how do you know what the contours are of your Grocer moment? And that's the challenge. So in this case, they're talking about humanitarian intervention in the context of stopping chemical weapons use. And that might be a very small slice of humanitarian intervention that has now been authorized as international law. It might not be all of the world of humanitarian intervention. It might just be the context of use of chemical weapons. The second thing is, in 1999, the Kosovo intervention was really broad. There were hundreds of sorties and bombs, thousands of bombs dropped throughout the country of Serbia. Here, it really was just 3 chemical weapons targets, one night, almost no civilian casualties, really narrow. And so, there are differences between the two contexts, and it makes it questionable. History will have to make sense of what does this precedent mean? How broadly should it be interpreted?
So this brings me back actually to the concept of the Grocer moment. Milena, one of the criticisms of the Grocer moment concept is that it is too early, in a sense, to tell whether the changes we discussed about the universal jurisdiction framework, self-defense, and humanitarian intervention are really new rules, let's say, of international law. This is what the criticism says. So what do you answer to this criticism?
Well, it is absolutely true that 40, 50, 60 years from now, we will have a better picture of, what actually happened and what new rules evolved as a result of what happened in Syria. And, just as a comparison, some of the greatest scholarship on the Vietnam War is actually being written today, 50, 60 years after the Vietnam War. Nonetheless, we believe that in light of everything that has happened so far, when it comes to essentially, conversations in the international arena, the actions, the airstrikes that we just mentioned that were conducted in 2018, when it comes to negotiations on this global compact on refugees and migrants, when it comes to the new use of universal jurisdiction, all of those things combined, we think are enough to make this argument that Syria does constitute a Grocer moment and that we're witnessing changes in international law that are occurring in an accelerated fashion in order to respond to the Syrian crisis.
That's very helpful. Paul, Michael, do you want to add something to this? Or maybe what would be interesting to really have a full grasp of this concept is to try and distinguish it between with the idea of tipping points, for example, or with the criticized concept of instant custom. So if you could share your views.
So some of the criticisms of our book have been, oh, you guys are advocating instant custom. And that is not what we're advocating. We're not saying that there's one resolution that's non-binding and suddenly, poof, it's law. What we're talking about are things that require widespread state practice and opinio juris. But we're saying that it's happening really quickly, surprisingly quickly. And that every once in a while in history, there are situations where there is this acceleration. Then the related criticism is, it's not so quick. You know, look at humanitarian intervention. People have been talking about that since Vietnam invaded Cambodia and Tanzania invaded Uganda, and India invaded East Pakistan, all to stop genocide. And they've been talking about it in 1999 with Kosovo and during the Iraq war with the no-fly zones. You know, this is just an extension of that. And then in which case they'll say maybe this is just the tipping point of what is an ordinary evolution over many, many years of customary international law. And that may well be. And so then there's this debate about whether something that is big enough to be a tipping point is a Grocer moment, or whether a tipping point is just one evolutionary thing, you know, that leads. And I don't know, that debate is sort of like how many angels can dance on the end of a pin. In the end, Syria has made a huge difference in the impact of international law, and I think we are able to prove that.
And how would you respond then to the concern of maybe fearful legal scholars who consider that framing this legal phenomena as a Grocer moment is potentially destabilizing? Maybe Paul, if you have a few thoughts about that.
Yeah, I think that as legal scholars, it's our responsibility not to be afraid. It's our responsibility to acknowledge reality. And we were all four of us were, you know, yourself, Rebecca, and the three of us were all trained in the old school of customary international law, opinio juris, state practice, decades, centuries. I think we have an obligation as international law moves more rapidly in the current generation that we're in. We have an obligation to catch up to it. You know, I'm on the long-term teaching track. I got 20, 25 more years. I'd be happy to like track humanitarian intervention for the next 20 years and then sort of write my law review article on it. But the reality is humanitarian intervention is way outstripped my ability to keep up with it, or my initial inclination. And so I think as scholars, we have an obligation, and I think led in particular by Michael and Milena, to lay out this concept of a Grocer moment, and to think through it and to identify instances where it's appropriate, so that, you know, our pro bono clients, others that are engaging in the international arena, are actually able to articulate a clear legal framework. And I guess the example I would give is, and Milena touched on this, but I want to stretch it out a little bit. At the time that the United States led the humanitarian intervention in Kosovo, Madeleine Albright asked her legal advisor, look, I need a legal opinion. We're going to do it. It's the right thing to do it. We have a moral obligation. I need a legal opinion, you know, justifying and articulating. And the State Department Office of Legal Advisor refused to give Madeleine Albright a legal opinion on the humanitarian intervention. Hence, we ended up with this debate of illegal but legitimate. That's not the case anymore. The British laid out a very clear legal argument, which was endorsed by the Americans and by the French. I think it's our job as scholars to get out of our comfort zone and to embrace an analysis of whether this has become a Grocer moment. And I think Mike and I have both worked at the State Department, and we were horrified that we actually get asked a question. We weren't there at the time, but we were there in the early 90s. But you know, they actually asked the lawyers for an opinion, which they don't always do. And the lawyers said, no, we're going to take a pass on this. Look, international law can't take a pass. if it's going to be relevant. We live in a very dynamic and fast-paced world. International law is keeping up, and now we as scholars and practitioners have to keep up as well.
And actually, just to follow up on that point, Paul, Harold Koh, who is now a professor at Yale Law School, at the time was the legal advisor to the State Department in the Obama administration. He actually made this argument. This is after he had finished his stint as legal advisor, but he made this argument where he said, and his argument was basically that humanitarian intervention should be legal under a carefully crafted legal framework. But he wrote, lawyers are not potted plants. He essentially said what Paul just said, how it is our duty as lawyers to advocate for changes in international law if international law is outdated, if international law is basically incapable of responding to, persistent crises. Because unfortunately, we're talking about Syria, but there have been other situations of a similar magnitude, similar humanitarian catastrophes where the international community was blocked, didn't do anything. Because part of the reason is that humanitarian intervention was illegal. But you can think back to Rwanda in 1994, when there was no Security Council authorization, and the world community basically sat back and allowed the genocide to take place. And so Harold Koh, like what Paul was just saying, said lawyers are not potted plants. It is our duty to act. It is our duty to advocate for change.
Thank you very much. And I think this nicely brings me to one question that I spotted in the chat. So I suggest that we open the floor now to the Q&A. And on the last point, I think it was very nicely framed and linked to one question in particular that wonders whether your analysis is descriptive, so trying to frame in the most accurate way the reality of this, let's say, social legal phenomenon, or if it's also implicitly incorporating a normative stance in favor of these new interpretations of the norms we discussed.
We have seen a criticism related to this that says that it's sort of an anti-colonial view of why Grotian moments are dangerous. And the view is basically that customary international law, as traditionally understood, is based on state practice. And it's not all of the states. It's often the most involved states in a particular situation. So space law, for example, it was largely a Grotian moment. It was created in a very short amount of time with just a few incidents by Russia and the United States and the other spacefaring countries. And so what some people say is, well, this Grotian moment idea is very undemocratic because it allows the big powers, the technologically advanced powers, the powers that can use force in a country like Syria to create customary international law that is then binding on all the countries in the world. And that is a normative argument against the Grotian moment concept. And I think in the end, what the person who asked the question is right. It's really a descriptive concept. We are describing a phenomenon that is occurring. And I guess we are suggesting that in articulating the opinio juris, countries should be really careful about what they say. They should be thoughtful about what they say. The other thing Harold Koh said when he was talking about the potted plants is, he said the risk of not being precise and saying, oh, it's just sui generis, is that every country in the world in the future will have its own interpretation of what that precedent means. And that is really dangerous. Whereas if the United Kingdom is very specific about the contours of humanitarian intervention as it applied to Syria, then you've really bottled it up and kept it safer. And I think that it's a two-part thing that we're doing. We're being descriptive, but we're also advocating for really clear rules.
Thank you. That's very helpful. So then there is a question on method and how you identify, signs of norm creation, basically. Someone says, couldn't we argue that the resolution of the Security Council on the right of self-defense is actually misguided and is in violation of international law itself? So, asking a little bit about to what extent we can actually also doubt the step made by the Security Council towards a new interpretation of the norm?
Well, you know, sometimes the United Nations organs, the General Assembly and the Security Council, have really midwifed the creation of new customary international law by articulating it and clarifying it. And I believe that's what the Security Council was doing. It was done unanimously. If you read the statements of the countries at the time, they said this is a really important principle and we will apply it in different contexts. There's an interesting one by China, who mentioned that there are terrorists on its borders that it will now be able to use this confirmed authority against. So this was wider than just the situation in Syria in the minds of the Council. There wasn't any objection by other countries, and the International Law Commission is currently finalizing its study on customary international law. And one of the things it says is that, you know, it's not just the countries that act and the countries that say things. You also have to look at the countries that acquiesce through silence. If their statement should have been expected and they didn't say anything, then that silence can be a form of consent under the right context. And I think that's what happened in the case of the 2014 Security Council confirmation of the right of self-defense against terrorist groups.
Milena?
Yeah. The other thing that I would just mention is when it comes to customary law, what one has to realize that it's sometimes states or other actors have to break existing norms in order to start working towards the elaboration of a new norm, right? So you have to, you know, break the law in order to create new law. And so I think we might be, you know, when it comes to, for example, humanitarian intervention, if we're going to argue that humanitarian intervention without Security Council authorization is now becoming a new customary norm, you know, that means that states engaging in such humanitarian intervention are breaking international law, which normally bans states from using force against other states absent self-defense or Security Council authorization, you know, in order to create this new norm. So I think we might be witnessing, you know, a moment of that sort where, you know, actors are breaking existing law in order to work towards the creation of a new norm.
So maybe we can move now to a slightly different issue related to how the Syrian conflict affected European member states, and linked also to the discussion we had on universal jurisdiction. And someone is asking for your thoughts on the legal obligation of European member states with respect to their nationals stuck in Al-Hol and other camps in Syria, and maybe because it's linked also to persecution matters. Someone is asking also your views on ICC jurisdiction for the crimes perpetrated in Syria over the past decade. I don't know who wants to start.
Milena is our European expert. Why don't you dive in?
That's, you know, that's a lot in sort of that one question, or it's a multi-part question. So let me start by talking about the obligation of, or, you know, I think that's part of the question, the obligation of member states to essentially rescue their nationals that have been perhaps stuck in refugee camps or imprisoned in Syria. So it has been, over time in traditional international law, one of the ways in which states have used force or interfered on the territory of other states has been to rescue and protect their nationals. So point number one, you know, arguably countries would, you know, could assert the authority to actually act in some forceful fashion to, rescue their nationals. But I think that what we've seen more is that there have been European nationals who've willingly or sort of pseudo-willingly gone over to Syria to fight with ISIS forces or with other terrorist organizations, and who have then expressed remorse, have then claimed the right to return to their host country. And so I think the bigger problem we've seen then is the pushback from those host countries, from those European countries who said, for example, well, we're now going to strip you of your nationality. You no longer get to return, or if you return, we're going to arrest you and prosecute you. So I think it goes both ways. It's about, rescuing individuals, but then it's also, there's been this pushback and this accusation that some European nationals have actually gone and joined terrorist organizations, and we don't want them we don't want them back anymore.
I will tell you a story that the ICC prosecution related at a conference I was at, and that is they were considering prosecuting European nationals for atrocities in Syria as a way of bringing the Syria situation to the International Criminal Court, because they do have jurisdiction of those nationals of state parties. But the main perpetrator that they had been investigating ended up dying. He was killed in armed combat. And so their entire investigation fell apart and they stopped pursuing it. It would have been really interesting had they taken up that case.
And that's really the paradox here. The ICC really only has potential jurisdiction over so-called foreign fighters. It doesn't have jurisdiction over Syrian nationals. And so, it is true that the ICC could prosecute cases involving foreign fighters if those foreign fighters are nationals of ICC member states. But at the same time, I'm not saying it's necessarily a bad idea, but it would be somewhat weird, for lack of a better word, for only those foreign fighters to face prosecution and for the Syrian perpetrators not to face prosecution anywhere.
Mm-hmm.
And I would just add, picking up on Milena's thoughts, that this is one of the reasons why the Syrian opposition in the Geneva negotiations has put on the table that the agreement should provide for ICC jurisdiction and retroactive to 2011. So I think when you find situations where you haven't had a Security Council referral, where Syria isn't a state party, that the negotiations may provide an opportunity for bringing in ICC jurisdiction. Now, that said, this proposal was made early on when it looked like there was going to be a peace agreement, that there was going to be a democratic transformation. Things have shifted on the field, and the future of the Geneva talks is somewhat in doubt. But at least that's another avenue that parties frequently try to pursue to bring in that ICC jurisdiction.
Thank you for your comments on these questions. They were recurrent actually in the chat, so I think they have been overall addressed. Someone is interested in knowing more about the failure of the Security Council to act because of the veto power of its permanent members and your view on this. So the one person asks if the international community needs a new mechanism to seize breaching of international law, or on the contrary, is it something that also pushes for this extensive version of, or these new modalities for humanitarian intervention?
Yeah, so the problem with the Security Council is under the UN Charter, for there to be reforms of the veto wielding permanent 5 countries have to approve it. And they have never been willing to vote in favor of anything that erodes their monopoly over that kind of power, which they were given when the UN was created. There have been all kinds of really interesting proposals, even small ones, like in order to have a veto in the case of genocide or crimes against humanity, there should be at least 2 countries involved. And if they can't get that as a reform of the UN Charter, as an amendment, why not as a gentleman's agreement among the permanent 5? Now, here's the thing. When the Security Council is paralyzed by the veto, and you start to see this power shift because the other countries in the world are not going to stand by it, it weakens the Security Council. And sometimes there is a tipping point there where the Council realizes it needs to address and embrace reforms, or it's going to lose all of its power. It's going to be shown as the emperor with no clothes. I'll give you a concrete example. In the case of Libyan sanctions after the bombing of Pan Am 103, they went on and on and on for a series of years, and every year fewer and fewer countries were enforcing the embargo against Libya. And the Security Council looked like a laughingstock. because nobody was following their required embargo. So ultimately, the Security Council permanent countries of the UK, the United States got together with Libya and agreed on this trial of the Libyan officials, not in the UK or in the US, but in the Netherlands. And the only reason that was agreed to and the Security Council blessed it is because the Security Council was in danger of being shown as a weak laughingstock. And those are the moments, and they happen every once in a while. And I think Syria is one of those moments where the Security Council might be willing to address reforms, because without it, their real power is the power of countries to voluntarily comply with sanctions and embargoes. And they've never imposed secondary sanctions on a country for non-compliance. Even when al-Bashir was hopscotching around the world in violation of the Security Council's referral to the International Criminal Court of the Sudan case, and the president and the prosecutor of the ICC went to the Security Council and said, listen, you sent us this case. You have to do something when these countries ignore the ICC's arrest warrant. The Security Council didn't take action, and it made it look really weak. And those are moments for change. And so that's what you ought to keep your eye on.
Thank you very much. So one question is actually very straightforward. Someone asks, so once we have identified a Grocer moment, what happens next? Is it a moment that we consider that there is a change and that therefore we foster, through this conceptualization, we foster the acceptation of new interpretation of the norms? What exactly a Grocer moment impels, triggers?
Yeah, I mean, I think there's
we write books and articles.
Go ahead.
I'm just teasing.
There are some practical implications. One is it makes it so countries that otherwise would be considered rule breakers now can act with the confidence that they are acting on the side of customary international law. And it will help them politically engender much more support. For example, soon after the Security Council debate about the humanitarian intervention in Syria, a number of countries said, if Syria uses chemical weapons again, we're going to join with the United States and France and the UK. And they weren't willing to say that before they thought that the law was on their side. So that's one of the practical implications. If there's a court case before the International Court of Justice or the International Criminal Court, it is helpful to be able to argue this is customary international law. And it also helps in terms of describing, the kinds of contours and preciseness in writing Security Council resolutions and General Assembly resolutions in the future, and how important that is.
And that gets, Rebecca, that also gets back, there was an earlier question about whether our book is, or the arguments that we lay out in the book, whether they're descriptive or normative. So, are we just describing Grocer moments, or are we actually proposing normative, changes? And so just adding on to what Michael said, I think we're really talking about this, a descriptive moment to start, right, where we're identifying these Grocer moments, but then it is our hope that, this gets picked up in the international community and that we actually start witnessing normative changes.
Thank you very much. That's very helpful. So maybe a last question on which all three of you might have something to share with us. So interestingly, in the literature, we have heard very often post 9/11, this change has been identified in the legal frameworks regulating the use of force, for example. So the starting point was 9/11, but you seem to give a special place, of course, to the Syrian conflict in that broader counterterrorism context. So could you tell us a little bit about what is, in a few words, what is specific to the Syrian conflict in reshaping the right of self-defense or humanitarian intervention, and what allows you to really identify this as a specific moment in this post 9/11 context?
Yeah, I don't think the world was ready right after 9/11 to embrace the US view that any country where there were terrorists was either with us or against us. And if you weren't successful at suppressing the terrorists, we were going to attack you. And back then, the articulations weren't very good. It was basically, we're going to just attack the whole country. And by the time you get to Syria, it is a much more narrow conception, and it is much more well-defined. And then you get the blessing of the UN Security Council. And I think it took those changes to make it acceptable to the international community.
And I also think Paul can have the last word here. I absolutely agree with Michael. I think 9/11 was significant. So, you know, we're not trying to overlook it. We're not trying to argue that it made no difference. But what's perhaps different about Syria is ISIS started becoming a threat worldwide. So as Michael mentioned, for example, when ISIS launched attacks in Paris or elsewhere, you know, it really became a global threat as opposed to just a local, you know, a regional threat. So I think that is different. I think there is more international consensus in essentially condemning ISIS. Not that the 9/11 terrorists were not condemned, but I think to some extent, other countries viewed the post 9/11 response as essentially an American war, American policy, American response. Whereas now I think we're seeing most of the world united against ISIS. So I think that's different. And I think, you know, it's an accumulation of different moments in time leading up to Syria. And each of those prior moments, including 9/11, is probably a contributing factor. But we're at a point in time that, as Michael stated, the international community might be ready for change in a way that it wasn't back in 2001 or in 1999 when the Kosovo crisis occurred.
And then I would just add, Michael and Milena have covered the humanitarian intervention and self-defense and terrorism quite well. But looking at the norm of justice, it was Nuremberg, and then it was nothing for 40 or 50 years. And then, you know, a dramatic number of tribunals, the ICC. And then we have yesterday, Ali Kushawi from Sudan was apprehended and is now in The Hague. And this was a Security Council authorized referral of Sudan to the International Criminal Court. The ICC charged him, I think, over a decade ago or about that long ago for genocide, crimes against humanity. That norm has become so deeply embedded. It's controversial, sometimes it's applicable, sometimes it's not, but it's there. And I think it's been continuing to deepen and grow since 9/11 in relation to a number of instances, but this norm of justice has taken root. And if the Security Council, when it has acted to refer Sudan, refer Libya to the ICC, drifts from that, the norm of justice isn't going to dissipate. There's simply going to be a power shift, and the norm of justice, you know, like water will always, you know, water always gets into the basement, no matter what we do. The norm of justice is always going to weave its way into a peace process or into the process of a resolution of a conflict. It's just a question of through what mechanisms and institutions. And our job as academics and scholars is to identify that evolution and that effort.
Thank you very much. It has been a fascinating discussion. I've also received a lot of messages from the audience that they were absolutely interested by your reflections. So on behalf of all the organizing institutions, I would like to thank everybody, the audience, for their engagement, of course, but also in particular, of course, our three speakers. You can attend more lectures at the Asser Institute very soon. Actually, next week we will be on Monday 15th with ICCT and Daniel Kipfer-Fascetti, the UN ombudsperson to the ISIL and Al-Qaeda Sanction Committee. On Wednesday 17th, we will celebrate the book launch of Human Dignity and Human Security in Times of Terrorism by Asser researcher Dr. Pelusen and Professor Martin Scheinen, a professor at the EY, but who was also the first United Nations Special Rapporteur on Human Rights and Counterterrorism. You can, of course, register on our website. Milena, Paul, Michael, my heartfelt thanks once again. Thanks for being with us tonight, and have a lovely end of the day, because you are still early in the afternoon. So thanks again to everybody, and enjoy the rest of your day.
Thank you, Rebecca.
Thank you.
Thank you, Rebecca. I really appreciate it.